Ever hit buy on an international e-commerce site, or maybe booked a flight with a foreign airline, and sort of wondered, how do these global giants actually operate within India's, well, intricate legal framework? Today, we're taking a deep dive into the fascinating and sometimes surprisingly expansive world of companies incorporated outside India under the Companies Act 2013. We've sifted through a pretty comprehensive stack of sources outlining the rules, the requirements, and even some clever exceptions.
Exactly. Our mission today is really to untangle these provisions for you, highlighting what's truly crucial for anyone looking to understand cross-border business in India. Get ready for some genuine aha moments as we reveal how the law, sometimes quite surprisingly, categorizes and regulates these global entities.
Okay, let's unpack this then. When we say foreign company in India, it's far more than just having a physical office, isn't it? The legal definition casts a remarkably wide net.
That's absolutely right. At its core, a foreign company is, a company or any recognized corporate body incorporated outside India.
Yeah.
But here's the kicker. It also needs to have a place of business in India, which can be a traditional physical office, or operate through what they call electronic mode, and actively conduct any kind of business activity here. It's those three elements together.
Right. And here's where it gets really interesting and maybe a little surprising for some listeners. This electronic mode part. I mean, the law seems to capture almost any online interaction with India, even without a brick-and-mortar presence. We're talking about everything from B2B and B2C transactions to data interchange, digital supply
This is
services.
much the whole digital economy.
Exactly. Offering or accepting deposits, financial settlements, web-based marketing, online advisory stuff, database products, even supply chain management. And think about online services like telemarketing, telemedicine, education, information research. Whether it's via email, mobile, social media, cloud computing, it's likely covered. It's incredibly broad. So for example, an Indian company, let's say ABC Entertainment Limited, has a foreign subsidiary, UVW Limited, providing satellite services to the group that's foreign subsidiary.
Okay.
Covered.
Makes sense.
Or think about airline companies operating just through booking agents in India. They're covered too. A shipping company from Japan, say Zakpak Ltd, with just a branch office here, that branch counts as a place of business.
Wait a minute. Oh.
And even a Singaporean company, maybe Search and Find Pete Ltd, selling goods only through e-commerce platforms in India without any physical branch,
Yeah.
likely considered a foreign company.
Right. The electronic mode kicks in.
Or even, say, a Dubai company as limited liability company, maybe their main server is in Dubai, but they provide cloud computing software to a client in India.
Yeah.
That also gets captured.
It's really quite impressive, actually, how forward-thinking this definition is. It clearly anticipates and, encompasses these modern digital business models. It ensures global entities can't just operate in a regulatory void simply because they don't have a traditional office here.
And yet, there's a specific carve-out, isn't there? Something policy-driven.
Yes. The IFSCs. Electronic offerings or listings of securities in India's international financial services centers. Those are not considered electronic mode for this definition.
Right. It's a clear signal, promoting business in those special zones.
Exactly. So the natural question then becomes, when does a foreign company not fall under this definition?
Good point.
Well, simply holding board meetings or, making business decisions in India doesn't automatically qualify them, not if there's no physical or electronic place of business and no actual business activity happening here.
Okay.
For instance, a company like, say, Redstone Limited, registered in Singapore. If they only hold board meetings in India, that doesn't make them a foreign company under these specific rules.
Got it.
Similarly, a company incorporated in Singapore that conducts all its business in Singapore, even if it's owned entirely by Indian citizens. It doesn't fall under these provisions. The activity has to be in India.
Okay, that clarifies the boundaries. So for those global companies that do meet that definition, what happens next? There's a particular provision, I believe, that makes a foreign company act almost like it's incorporated right here in India.
That's a crucial point, yeah. It's about ownership.
Yeah.
If 50% or more of a foreign company's paid up share capital, and that can be equity or preference shares, or a mix is held by one or more Indian citizens or Indian companies or a combination, then that foreign company essentially has to comply with a whole chapter of the Companies Act, Chapter 22, and other prescribed rules, just as if it were an Indian company itself.
Right. Could you give an example, maybe?
Sure. Imagine Emaar Company LLC, incorporated in Dubai. Let's say 26% is owned by Hinduja Company Limited, an Indian entity,
Okay.
and another 25% by Vaishali Company Limited, also Indian. That brings the total Indian ownership to 51%.
Over the threshold.
Exactly. So Emaar Company LLC must now follow those specific provisions of the Companies Act as if it were incorporated in India.
Wow. That really highlights the reach of Indian law, doesn't it?
Yeah. It really does. It allows India to exert significant influence, you could say, over entities incorporated far away, based specifically on that level of Indian ownership. It ensures a degree of local accountability.
Okay. So once a foreign company decides, right, we're setting up a place of business in India, the clock starts ticking immediately, correct? There's a pretty strict deadline for initial registration.
That's right, 30 days. Within 30 days of actually establishing its place of business here, every foreign company has to deliver a set of crucial documents to the registrar for formal registration.
And here's a detail that often catches people off guard. All these documents, no matter where their office is, Bangalore or Mumbai, wherever they have to be delivered to the registrar whose jurisdiction covers New Delhi. Centralized point.
Yes, that's an important operational detail. And what do they need to provide? Well, essentially, a certified copy of their core constitutional documents.
Like their charter or articles.
Exactly, the documents that define how the company operates. And crucially, if these aren't in English, say, the company's German, like Jackson and Jackson LLC, then a certified English translation is absolutely mandatory.
Okay, translation's key. What else?
They also need the full address of their main registered office outside India, and then a really detailed list of all their directors and the company secretary. This gets quite granular.
Also.
We're talking full names, any former names, father's, mother's, spouse's name, date of birth, residential address, nationality of origin if it's different passport details, PAN number if they have one, occupation.
Wow.
And even if they hold directorships in any other Indian companies, including their DI, the company's name, and CIN, plus any other directorships globally, and for the secretary, their membership number, email IDs too. It's comprehensive.
It really paints a full picture. What else is on the list?
They need to designate one or more individuals living in India who are officially authorized to accept legal notices or documents for the company. Their names and addresses are needed.
The local point person.
Precisely. And, of course, the full address of their main place of business in India. They also need to disclose if they've opened or closed any places of business in India previously.
Right. History matters.
And finally, a declaration, stating that none of the directors or the authorized representative in India has ever been convicted or debarred from forming or managing companies, either in India or abroad.
Okay, that's quite a package. How is this submitted?
It's all done using a specific form, FC1, along with the prescribed fees.
And isn't there an RBI requirement too?
Yes. You need an attested copy of approval from the Reserve Bank of India under FEMA regulations, if that's applicable, or, alternatively, a clear declaration from their authorized representative stating that no such RBI approval is actually needed for their particular business setup.
Got it. So that's the initial setup. What if things change later on, like they move their main office overseas or a director change?
Good question. This isn't a one-time filing. If any of those initial details change, the principal office address, director details, the authorized representative, anything listed initially, the foreign company must file another form, FC2.
Okay.
This form details the alterations, and it needs to be filed within 30 days of that change happening, again, with the required fees.
So if, say, Swift Pharmaceuticals' Singapore office address shifted on March 1st, 2024,
they'd need to submit that FC2 form detailing the change by March 30th, 2024. Keeps the record current.
Right. So beyond this initial setup and updates, there's a strong focus on ongoing compliance too, particularly around financials, isn't there?
Absolutely. Financial transparency is key. Every calendar year, these foreign companies have to prepare a balance sheet and a profit and loss account specifically for their Indian business operations.
Just the Indian part.
Yes, specifically for the Indian operations. And this needs to follow the standard accounting formats laid out in Schedule III of the Act, or, as close to them as practically possible.
Okay. And what's this about the parent company financials?
Yeah.
That seemed interesting.
Yes. They also need to deliver copies of the latest consolidated financial statements of their parent foreign company to the registrar. These are the same statements they submit in their home country.
Ah, so it's transparency at both levels, local Indian operations and the global parent.
Exactly. It gives the regulators a fuller picture.
When are these due? Is there a deadline?
These financial documents, the Indian P&L balance sheet and the parent's consolidated statements, must be delivered to the registrar within 6 months of the close of the foreign company's financial year.
6 months. Is there any flexibility?
There is, actually. The registrar can grant an extension, but only for special reasons and only up to an additional 3 months.
Okay. So if a company like, say, 5K Cosmetic Shop Plecac follows a calendar year ending to, say, 31st.
Their documents would typically be due by June 30th of the following year, unless they get that special extension.
Got it. What else needs to go in with these financial?
Along with the core financial statements, they need to attach a few other important documents.
Like what?
Things like a statement of related party transactions detailing dealings between the Indian branch and other group entities. Also, a statement of repatriation of profits, showing how profits earned in India are sent back. And a statement of transfer of funds, which includes details on dividends, if any, and other fund movements.
Okay, quite thorough. Now, this raises a practical issue.
Mhm.
What if their parent company back home follows a different financial year, say July to June, while India's typically April to March?
That's a common scenario. The good news is the central government can help here. On application by the foreign company, the government can allow them to align their Indian financial year with their overseas holding or subsidiary company's year.
Oh, that makes sense for consolidation.
Exactly. So, for example, if ROK Limited, operating in India, is a subsidiary of HOK Limited in Australia, and HOK uses a different financial year, ROK could apply to the central government to adopt HOK's financial year for its Indian reporting.
That's helpful. And what about audits? Are the Indian accounts audited?
Yes, and this is critical. The accounts relating specifically to the Indian business operations must be audited by a practicing chartered accountant right here in India.
So local audit standards apply.
Pretty much. The provisions of Chapter X of the Companies Act, which deals with audit and auditors, apply with necessary modifications, so it's a proper Indian audit.
Okay. So it's not just about filing documents behind the scenes. Foreign companies also need to be clearly identifiable to the public, right?
Precisely. Visibility and transparency are important. They're required to conspicuously display their company name and the country where they were incorporated
Where exactly?
on the outside of every office or place where they conduct business in India. And this display needs to be in clear, legible English characters and also in the characters of the local language or one of the main languages used in that specific area.
Both English and local language. That's
Okay.
important.
Very. And that same information, name, and country of incorporation must also appear, again in legible English characters, on all their official stuff. Business letters, billheads, letter paper, notices, official publications. Basically, anywhere they represent themselves formally.
Right. What if their liability is limited, like an LLC or something similar?
Good point. If the company's liability is limited, that fact also needs to be clearly stated.
Why?
In every prospectus they issue on all those business communications we just mentioned, letters, billheads, etc., and also conspicuously exhibited on the outside of every office or place of business in India, it's about ensuring anyone dealing with them knows the nature of their liability structure.
Makes sense. Total clarity. How about serving legal documents on them?
The law makes that fairly straightforward. Any official process, notice, or document is considered sufficiently served if it's addressed to that authorized person resident in India whose details they filed with the registrar.
Also contact.
And then it's either left at or sent by post to that registered address or even delivered electronically.
Okay. Clear mechanisms there. Is there an annual filing requirement beyond the financials?
Yes, there is. Foreign companies also need to prepare and file an annual return.
What's that?
It's done in Form FC4 along with the fees. It has to be filed within 60 days from the last day of their financial year. It basically contains key particulars about the company as they stood at the close of that financial year, a snapshot update.
Got it. And record keeping?
They're mandated to maintain specific books of account at their principal place of business in India. These records need to detail all money received and spent, sales and purchases made, and their assets and liabilities specifically relating to their business in India. Local books for a local business.
And do other general Indian company laws apply to them as well?
Yes, several key provisions apply mutatis mutandis' meaning, with necessary changes to their Indian business. This includes rules around debentures, Section 71, the registration of charges on assets, Chapter 6, and importantly, the government's powers for inspection, inquiry, and investigation, Chapter 14.
So they're subject to quite a bit of the Indian corporate framework.
They definitely are, especially concerning their Indian operations.
Now let's shift gears slightly. What if a foreign company wants to raise capital directly from the Indian market, offering securities here?
Yes. That's a whole separate and quite regulated area. Whether they have a physical presence here or not, if they want to offer securities in India, specific rules kick in.
What's the main rule?
Well, basically, no person can issue, circulate, or distribute any prospectus in India offering securities of a foreign company unless that prospectus meets certain conditions. It must be dated, signed, and contain very specific information.
Okay. What kind of specific information needs to be in that prospectus?
It has to detail the company's constitution, the instrument defining it. It needs to specify the laws under which it was incorporated.
Hmm.
Crucially, it must provide an address in India where copies of these constitutional documents and their certified English translations can be inspected by potential investors.
Transparency again.
Absolutely. It also needs the date and country of incorporation and must state whether the company has established a place of business in India, and if so, its principal office address here.
Okay.
Plus, it generally needs to cover all the standard matters required in any prospectus under Section 26 of the Act, similar to an Indian company's offering.
Is there any exception to providing all that historical info?
There's an interesting nuance. Some of those points about the Constitution, incorporation laws, and inspection address, they actually don't apply if the prospectus is issued more than 2 years after the company first became entitled to commence its business.
Ah, okay. So if a company's been operating for a while.
Exactly. Like Mere Company LLC, incorporated in April 2019, if they proposed offering securities in, say, 2022, they might not need to include those specific older incorporation details in the prospectus.
Got it. What about experts mentioned in the prospectus,
Yeah.
like auditors or valuers?
Very important point. If the prospectus includes any statement purported to be made by an expert, two things are critical. One, that expert must have given their written consent to the issue of the prospectus, including their statement.
Hmm.
And two, that consent must not have been withdrawn before the prospectus is delivered for registration. This fact that consent was given and not withdrawn must be explicitly stated in the prospectus itself adds credibility.
Right. Does the prospectus itself need to be registered somewhere before it's issued?
Yes, absolutely. Before it can be issued or circulated in India, a copy must be delivered to the registrar for registration.
How does that work?
This copy needs to be certified by the company's chairperson and 2 other directors, confirming it's been approved by a resolution of the managing body, like their board. And then, the prospectus itself, when issued to the public, must state clearly on its face that such a copy has been delivered to the registrar. It's a key compliance check.
Are there other documents needed when registering the prospectus?
Yes, several attachments usually go with that copy to the registrar. Any required expert consents we just talked about.
Mm-hmm.
Copies of contracts for appointing the managing director or manager, if any. Material contracts that are not in the ordinary course of business and were entered into within the past 2 years.
Okay.
Any underwriting agreement related to the offer, and a power of attorney if the prospectus was signed by an authorized agent rather than the directors themselves.
That makes sense. Now, this brings up something quite unique to India. Indian Depository Receipts, or IDRs. Can you explain what those are?
IDRs. What's fascinating here is they're essentially a mechanism allowing foreign companies to raise capital directly from the Indian market using a specific instrument. An IDR is basically an instrument, like a receipt, created by a registered domestic depository here in India. It's authorized by a company incorporated outside India that's making an issue of these depository receipts.
So it represents foreign shares but trades in India.
Kind of, yes. It allows Indian investors to invest in foreign companies more easily, and foreign companies to tap into Indian capital pools. Think of it as a bridge.
And who sets the rules for these IDRs?
The central government sets the specific rules for IDR, offers things like the disclosures required in the prospectus, how the IDR should be handled in the depository system, the roles of custodians and underwriters, and rules for their sale, transfer, and transmission.
So foreign companies issuing IDRs need to follow these specific government rules.
Yes, absolutely. They need to comply with those specific IDR rules, in addition to the general requirements from the Securities and Exchange Board of India, SEBI, specifically their regulations on capital issues and disclosures, and any directions issued by the Reserve Bank of India. It's multi-layered compliance.
Got it. Any examples of companies using IDRs?
Well, the historical note is that Standard Chartered plc was actually the first global company to file for an IDR issue in India way back in 2010. Paved the way.
Interesting piece of history. Okay, so we've covered getting in, operating, raising capital. What about major transitions? Like if a foreign company wants to merge with an Indian one or decides to wind down its Indian operations.
Right, big moves. For things like compromises, arrangements, and amalgamations, essentially. Mergers the rules from Chapter 50 of the Companies Act generally apply, with necessary changes, of course. This applies specifically to schemes involving Indian companies and companies incorporated in jurisdictions that the central government has specifically notified.
So a foreign company can merge with an Indian one or vice versa.
Yes, it's possible. But, and this is crucial, it requires prior approval from the Reserve Bank of India. The RBI has to greenlight it.
And how are shareholders paid in such a cross-border merger?
The consideration can be in cash or through depository receipts or potentially a combination of both. And here's an important clarification specifically for this merger section. The term foreign company is actually defined more broadly here. For mergers under this section, it means any company or body corporate incorporated outside India, whether it has a place of business in India or not. So it covers even foreign companies without an Indian operating presence, if they're merging with an Indian entity.
That's a significant distinction from the general definition we started with.
It is, yeah, tailored for the merger context.
Okay. And what about winding down? If a foreign company wants to close its Indian business?
The provisions for winding up, found in Chapter X of the Act, apply mutatis mutandis to the closure of the place of business of a foreign company in India, but specifically in cases where that foreign company has raised money through securities offerings in India under this chapter, and those funds haven't been fully repaid or redeemed yet. In that scenario, the Indian winding up rules apply as if it were an Indian company being wound up.
Right. Protects the investors or lenders who put money in.
Exactly.
So we've laid out a lot of rules. What happens if a foreign company, well, doesn't play by them? Are there penalties?
Oh, yes. There are significant penalties for non-compliance with the provisions we've discussed under Chapter 22. If a foreign company contravenes these rules, the company itself is punishable with a fine. It won't be less than 11,000 rupees, but it could extend up to 3,000 rupees.
So, for example, if that German company, Morgan Stern Digicables GmbH, failed to deliver documents on time,
they'd be looking at a fine somewhere in that 1 lakh to 3 lakh rupee range.
and does it stop there? What if they just keep ignoring the rules?
No, it doesn't stop there. If it's a continuing offense, there's an additional fine. This can be up to 50,000 rupees for every day after the first day that the contravention continues. That can add up very quickly.
Wow. Okay. That's a strong incentive. What about the people running the company? The officers?
They're personally liable too. Every officer of the foreign company who is considered in default can be punished with a separate fine. This starts at 25,000 rupees, but could go up to 5,000 rupees per officer.
So both the company and the individuals responsible face significant fines?
Yes. The law targets both.
Now, this raises a really critical question. If a company fails to comply, does that mean all the business deals they've already done become invalid? Like, are their contracts void?
That's a great question, and the answer is actually quite interesting. The law specifically states that any failure by a foreign company to comply with these provisions shall not affect the validity of any contract, dealing, or transaction they've entered into. Nor does it affect their liability to be sued in respect of those dealings. So if they owe you money under a contract, you can still pursue them legally, even if they haven't filed their paperwork correctly.
So you can still sue them?
Yeah.
That protects the Indian counterparty?
Exactly. But here's the twist.
Oh.
The non-compliant company itself cannot bring any suit, claim any set-off, make any counterclaim, or institute any legal proceeding in respect of any such contract, dealing, or transaction.
Until
the company has fully complied with all the applicable provisions of the Companies Act.
Wow. So they can be sued, but they can't sue or enforce their rights until they get compliant.
Precisely. It's a very powerful lever to ensure compliance. They lose their access to the legal system to enforce their own contractual rights if they haven't followed the rules for being here in the first place.
That is a clever mechanism. What about pretending to be registered?
That's also covered. If any person or group trades or carries on business using a name or description that implies they are a foreign company registered under the Act or rules when they actually aren't, that person or group can be liable for investigation under Section 210 of the Act. So misrepresentation is taken seriously.
Good to know. And finally, are there any general exemptions possible?
Yes, the central government does have the power to provide exemptions from certain requirements. This is particularly relevant for foreign companies operating within India's international financial services centers, those IFSCs we mentioned earlier.
So specific exemptions for IFSCs likely to encourage activity there.
That seems to be the policy intent, yes, especially regarding prospectus rules and securities offerings within the IFSC framework.
Okay. Wow. We have certainly covered a lot of ground today. From that surprisingly broad definition of a foreign company, stretching right into the digital realm, to the really strict documentation, the financial reporting for both Indian ops and the parent, the public identity requirements, and then those complex rules around raising capital and even merging here in India.
Yeah, we've seen how Indian law meticulously aims for transparency and compliance from these global entities. It offers some flexibility, like with financial year alignment or IFSC exemptions, but it also imposes quite significant penalties for non-adherence. It's a real balancing act trying to regulate effectively, but also facilitate foreign business participation.
So what does this all mean for you, the listener? Well, the next time you encounter a global brand operating in India, maybe it's a streaming service, an imported product you buy online, or you walk past a local branch office, you'll know there's this whole detailed, intricate legal framework guiding their presence here. It really makes you think about the hidden layers of compliance behind almost every international transaction you might be part of.
It really does. And that begs a bigger question, perhaps. How do these very detailed regulations ultimately shape India's attractiveness as a destination for foreign investment and global business? Is the balance right? And looking forward, as technology continues to just explode and evolve AI, more complex cloud structures, maybe the metaverse, how might these legal definitions and compliance requirements themselves need to adapt in the years to come? Will electronic mode need another update soon?
Definitely something to ponder as you go about your day.